Hello to everyone. I'm Jessica Goldstein, Education Program Coordinator at ASRM. Before beginning the webinar, I'd like to go over a few housekeeping items. To make sure we can cover all the content in the allotted time, everyone's line except for the speakers will be muted. We'll devote about 15 minutes at the end of the presentation to questions. Please feel free to type a question in the chat window at any time. We'll read as many selected questions as possible to the presenters during the allotted question and answer time. A recording of this webinar will be archived on the ASRM website in the coming weeks. Please watch your email for notification. To introduce our speakers today, I'll turn things over to Professor Judith Darr, Chair of the ASRM Ethics Committee.
Thank you so much, Jessica. Thank you and welcome to all. We're just delighted to have you join us today. As Jessica said, my name is Judy Darr, and I have the privilege of chairing the ASRM Ethics Committee. And we bring you on a quarterly basis these webinars to explore issues in reproductive medicine that are of interest to our membership and, frankly, to many around the world. So today's topic, Dilemmas in Third-Party Reproduction, Perspectives in Medicine, Law, and Ethics, has certainly vexed the field of reproductive medicine since its modern introduction in the 1980s. Many of us perhaps remember the case of surrogacy known as the Baby M matter. And so it's been decades, over 3 decades, that reproductive medicine experts in both law, medicine, and ethics have grappled with these questions about the allocation of rights and responsibilities when collaborative family formation plans proceed. Each of today's speakers have been carefully selected and bring with them much experience and wisdom in this arena. And as the title of our presentation suggests, they hail from 3 distinct fields within the third-party ART practice. So it's my pleasure to introduce the speakers to you, and I'm going to introduce them in the order in which they will present, and then I'll have just a wrap-up housekeeping matter, and we'll begin the program. We're delighted to welcome first Dr. Robert Boonstafar. Dr. Boonstafar is an OBGYN and REI who is a principal of HRC Fertility Doctors here in Los Angeles, mostly in the San Fernando Valley. He is a graduate of the University of Southern California Keck School of Medicine, and he currently holds an appointment as a clinical assistant professor at the Keck School at USC. Dr. Boonstafar has many awards, and I'm just going to isolate a couple of them, including the Vital.com Compassionate Doctor recognition, which he earned in both 2009 and 2011, as well as that group's Patient Choice Award. So welcome, Dr. Boonstafar. And he's, of course, going to talk to us about clinical perspectives on third-party reproduction. We move next to our legal expert, Andrew Vorzimer, who will talk with us about legal aspects of gestational carrier arrangements and other third-party agreements. Andy, if I may, Vorzimer is a partner with the law firm of Vorzimer and Masterman, also in Los Angeles, also in the San Fernando Valley. He is a graduate of Whittier Law School, and it's fair to say that Andy is one of the world's leading experts in the ART field, having represented clients in third-party reproduction for now over 25 years. In addition to his law practice, Andy is also a very generous mentor and educator to many of us in the field. I've attended his lectures and learned quite a bit from him. He has active roles in ASRM, in AAART, which is the American Academy of ART Attorneys, the International Federation of Fertility Societies, Resolve, and other organizations. Andy has also played a key role in developing the law in this field, particularly here in the state of California, having testified and helped draft some key pieces of legislation that codify and govern the practice of third-party reproduction in our state and across the country. Welcome to Andy. Finally, our expert on ethical and social considerations of third-party reproduction, we welcome Kathleen Hammond. Kathleen completed her PhD in sociology as a Gates Cambridge Scholar at the University of Cambridge. Her research has focused on the experience of infertility and the markets and regulation of donor gametes, surrogacy, and egg freezing. She's had a number of fellowships, including one with the Foundation Brochure in Switzerland and the Center for Biology and Society at Arizona State University. She was also involved with WHO in organizing their glossary and guidelines on infertility, something I think many of us turn to currently. She is also currently pursuing her JD at the McGill University Faculty of Law. So welcome to Kathleen, and welcome to all of our speakers, and of course, most importantly, to our audience. So as Jessica said, each speaker will present for about 12 to 15 minutes and will guide you through their PowerPoint presentations. And we welcome questions throughout the presentation. You can type your question into the chat window that's at the bottom of your gray toolbar at any time. And throughout the presentation, Jessica will be collecting and organizing those and will shepherd that part of the presentation. We certainly encourage questions. Typically at this point in the presentation, before turning it over, I would announce our date and topic for the next webinar, but we're still discussing that. And so it's my opportunity to say to the membership, please send any suggestions for topics that you'd like to have us cover. We're always welcome for that. So with that introduction, I'm going to turn it over to Dr. Mustafa, and Jessica will pull up his slide set, and we'll begin with the substance of the program. Thanks, everyone, so much.
Thank you so much, and I'm so happy to be a part of the webinar this afternoon, and I think our slides are up right now. I'd like to tell you a little bit about our practice and discuss gestational surrogacy from medical screening to embryo transfer. I am the Director of Clinical Research for our facility at HRC Fertility, and I do have two disclosures. We have research grants here for Allergan and Ferring Pharmaceuticals, and I'm also a consultant and lecturer internationally for MSD Merck Pharmaceuticals. A little bit about our learning objectives. At the conclusion of this webinar, participants should be able to discuss the screening process of a gestational surrogate from the medical side, and also describe the background approach to counseling the intended parent and the gestational surrogate for embryo transfer. Talk a little bit about HRC Fertility and our practice demographics. We are a large regional West Coast program. We do several thousand cycles of IVF annually, over 3 IVF labs, 12 doctors, and approximately 8 offices. About 1/3 of our volume is third-party reproduction and gestational surrogacy, both locally and all over the world. Patients are coming to see us. And we are also observing a growing number of pre-implantation genetic screening cases in all areas of assisted reproductive technology cycles, and including third-party reproduction and gestational surrogacy. And we'll talk a little bit about that as well. And as I had mentioned, a lot of international patient volume due to the laws, regulations in California. So I really just want to start off our discussion about ovarian stimulation in IVF and explain to all the disciplines that are calling in today why this is the most important part of the success of the process. There's a great study that was published in Human Reproduction in 2011 by Sunkara's group, and they looked at 400,000 cycles of IVF from the United Kingdom in an almost 20-year period from 1991 to 2008. And what you could see in the slide, with one axis being the live birth rate and the other axis being egg number, you could see that there was a strong association between the number of eggs and the live birth rate. And in fact, the live birth rate rose very dramatically with an increasing number of eggs up to 15 and plateaued between 15 and 20 eggs. In the study, we observed a steady decline of live births when there was more than 20 eggs. And now, retrospectively, as we know more research about the endometrial development and what happens to the uterine lining and the uterus during stimulation, this decline in success rate may be from the overstimulation effects of the uterine lining in what we would call autologous IVF. In other words, too many hormone injections, too high of a level of hormones. You still get a lot of eggs, but it disrupts the endometrial lining and uterine lining when you're putting the embryo back in. So our target number of eggs is somewhere around 20, and a good oocyte count is really important in gestational surrogacy cases to maximize the efficiency of a single stimulation. So now let's talk about screening of the gestational surrogate. So we know that our goal is to get an optimal number of eggs and embryos, and of course, to optimize the outcome of that stimulation, we'd like to get a great environment in which to implant the embryo. So most of the time, you will typically get a surrogate to our office that has come from an agency. Not always. There can be independent surrogacy cases of family members or very close friends. But basically, when they're coming from a surrogacy cycle from an agency, they typically have done some preliminary background screening of this patient. There's some psychological screening that is done, background check that is done, criminal record check, financial credit report, in-person interviews, sometimes even at their own home. References are provided. A transitional medical record review is done sometimes by a nurse at the agency, the surrogacy agency that may be bringing the surrogate to us. And oftentimes, the better agencies will get an OBGYN clearance letter to us to make sure that this is even a viable candidate. So there is always, by far, in most cases, some preliminary screening that occurs before the surrogate comes to us. After a surrogate is chosen by the intended parent and they've had a meeting, typically a match letter is issued to the clinic with identification, and that way we can contact this person to set up and conduct a full medical screening. So when they arrive at our office, we like to validate that this is the correct person. We sign them in and scan in their picture ID of both the surrogate and their partner. By then, we have a full review of the medical history, including birth records and previous deliveries. So the agency is typically great at getting all of the previous prenatal care records to us so that we could review them in the context of the history and physical on the day of the screening. We meet with them directly. Here will history and physical exam. We will be for infectious disease, and the question that is becoming more interesting and posed on a daily basis is should we even be doing Zika testing as part of the panel of infectious disease that is done. So we want to make sure the infectious disease labs on all parties are FDA compliant. There is laboratories that keep the stringent criteria for the FDA. The FDA does come to our office and audit the charts to make sure that all infectious disease are done properly. We do a urine drug test. We make sure that the surrogate is providing a specimen, and we make sure the chain of command is appropriate to make sure it's her specimen. On the day of the exam, we do a pap smear, a breast exam, a mammography if it's indicated or needed, and then we do a very important part of the screening is an examination of the uterus, whether it's a hysteroscopy, which is placing a small flexible camera inside the uterus and looking through a video monitor, or a saline infusion ultrasound, which can also look for many pathological processes like fibroids or polyps or scar tissue. At that screening visit, we will review the informed consent with the gestational surrogate. The doctor will let them know all the risks and the alternatives of gestational surrogacy. They will sign the consent and with the MD and the nurse as the witness. If there are any abnormalities that are of any kind of concern that there may be a slightly higher risk pregnancy, we would then refer them to an appropriate consultant in the field, such as a maternal fetal medicine specialist. On the day of the screening, I prefer to discuss embryo transfer, talk to them about the values of single embryo transfer, and to make sure that at least the surrogates are on board. When the labs are in and they are negative, in other words clear, we issue a medical clearance that the surrogate's been medically cleared, and then legal contracts can be initiated. When we get word back from the attorneys that all parties have signed contracts and legal clearance has been issued, then we begin to initiate the in vitro fertilization cycle. So in preparation for embryo transfer, I think it's extremely important to discuss with the surrogate mother a comfortable and convenient time for embryo transfer to enhance compliance for aftercare. The vast majority of the time, we try to do the transfers on Thursdays or Fridays in preparation for them, just basically resting and relaxing over the weekend. Despite the fact that there's no evidence that bed rest can make any significant difference in pregnancy rates, it tends to, for lack of better terms, really disturb and freak out the intended parents if you just say, here's your transfer and go ahead and it's fine to go to Disneyland tomorrow. So we typically will encourage them to, relax the day of the transfer and 2 days after, be at the house, and minimize their activity. So when we are getting the feedback from the surrogate that the day of transfer is acceptable to them, there's no conflicts with their family, their work, the intended parents are comfortable with it, we send out the calendars so that everyone can prepare for the day. We will typically start with the birth control pill in the intended parent or the oocyte provider and the surrogate. We like to synchronize the menstrual cycles of both parties with the birth control pill. When it comes to the surrogate, we then overlap with an injectable medication called Lupron so that we can stop the birth control pill, and then they will continue to take Lupron during the preparation of the uterus with estrogen and progesterone to prevent ovulation so that we can ensure that when there is an embryo transfer that the pregnancy is coming from the transfer and not ovulation from the surrogate. There are many protocols to prepare the endometrium or the uterine lining. What we typically use is injectable estrogen, but oral estrogen or estrogen by patch is perfectly appropriate. This is done for about 2 to 3 weeks. The lining of the uterus is measured. A uterine lining of approximately 8 millimeters or higher with a trilaminar appearance seems to be optimal to continue the stimulation of the oocyte provider and the surrogate. We then shift from estrogen only to estrogen and progesterone. The estrogen is continued and overlapped by an additional progesterone injection or vaginal suppository for 5 days. And by and large, embryo transfer is taking place after the 5th day of progesterone administration. On the day of embryo transfer, we really encourage the intended parents to be there, and the gestational surrogate, the intended parents, the medical doctor, and the embryologist all sign the informed consent for transfer. We have a separate consent for transfer. We review the ASRM embryo transfer guidelines, and then we perform the embryo transfer. Typically speaking, weeks prior to this, it's planned, we discuss this, we have a discussion about how many embryos we're going to transfer, specifically encouraging single embryo transfer in conjunction with the pros and cons of comprehensive chromosomal screening or PGS testing, which is a screening test of the embryo by which you laser off some of the peripheral cells of the embryo the day before transfer, and a chromosome report comes out letting you know of all 23 pairs of chromosomes. And some patients are encouraged to do this despite the age of the oocyte provider. If the intended mother is, say, 38, 39, that may build more evidence to screen these embryos to reduce the chance of miscarriage or implantation of a chromosomally abnormal fetus, which can cause significant amount of problems for the intended parent and the surrogate. And sometimes, if it's a young oocyte donor, Many couples are choosing to do this to try to maximize the efficiency of the cycle. And at the same time, minimizing the multiple birth complications and termination of multiple births and the pregnancy issues that follow subsequently. Our follow-up care, again, it varies from clinic to clinic, but speaking for our clinic, we typically will manage the gestational surrogate by ultrasounds every 2 weeks until about 6 to 10 weeks of pregnancy. Some centers will release the surrogate at 6 weeks when they see a heartbeat. We typically will hang on to our surrogates until about the 10th week. That way the gestational surrogate can be discharged to the OB office, and we can wean off the supplemental hormones at around 8 to 10 weeks, depending on the clinical symptoms and the hormone levels. The placenta of the fetus will typically start making its own estrogen progesterone around 8 weeks. We encourage intended parents and surrogates to get a thorough, detailed ultrasound and blood work of the fetus at around 11 to 12 weeks by a perinatologist or a maternal fetal medicine specialist to ensure that an early detection of any kind of anatomical abnormality, etc., can be diagnosed early to prevent any kind of late second trimester complications or termination issues. With that said, I sincerely appreciate the opportunity of being part of such a great webinar. I thank you, and if there are any questions, we could take them now or whenever the moderator would like for us to take questions.
We'll be taking questions at the end. Please type any questions in the chat box down in the bottom of your gray toolbar. And Mr. Borsberg, it's your turn.
Thanks, Judy and Jessica, for organizing today's webinar and for everyone taking time out of your busy day to listen to us. I appreciate it. I'll try to get through this as quickly as I possibly can so we have time at the end for questions. I have no disclosures to make, no conflict of interest. Learning objectives. At the conclusion of today's presentation, participants should be able to explain the importance of proper mental health screening for potential gestational carriers and egg donors, and describe the consequences of improper screening. Number 2, discuss embryo testing from a legal perspective. 3, determine the enforceability of contractual provisions as they relate to the gestational carrier and or egg donor's behavior concerning her lifestyle, diet, exercise, travel, etc. 4, determine the enforceability of contractual provisions as they relate to multifetal selective reduction and termination of pregnancy. Finally, 5, describe the role of an attorney as a counselor and the importance of preserving the relationships between the intended parents, the gestational carrier, and or their egg donor. My presentation today is intended really to provoke discussion and questions. With a few exceptions, much of what I'm going to talk about today, I think you'll find there really is no bright line answer to many of these questions, and hopefully we'll have a chance to have a discussion about it later. First thing I'd like to talk about is screening. You know, many of the legal issues that we have to deal with can be avoided if there's proper mental health screening of potential gestational carriers and egg donors. Dr. Bustenfar has outlined some of the screening that takes place, both medically and psychologically, but I'd like to delve a little deeper into that. The first question is, who should conduct the screening? Should it be a marriage and family therapist? Should it be a marriage, family, and child counselor? Or should it be someone with a doctorate, a psychologist with a PsyD or a PhD? And what's interesting is if you take a look at this, ASRM does have some practice guidelines, recommendations with respect to who ought to be doing these assessments. And the language used by ASRM, at least as recently as January of 2015, is that it ought to be done by a qualified mental health professional. But that's not defined. There's further language in the practice guidelines that say that psychological test data should be handled in accordance with the American Psychological Association's ethical standards. But then if you take a look at the American Psychological Association's ethical standards, you'll see that they define that as people who have a doctorate. So the question is, given some inconsistency in these guidelines, is a psychological assessment or screening done by an MFT or MSCC sufficient? Ought it be a PsyD or a PhD? And even more questions are, who ought to be screened? If we're looking at a married gestational carrier or egg donor, should her husband be part of the screening? Should the screening take place in person, or is it sufficient to be telephonic, or ought to be something like Skype or FaceTime? If she's not married but cohabitating with a partner, ought that person be part of the screening process? And again, there are really no clear-cut answers. There is no standard of care necessarily in the industry that give practitioners a bright line to know whether or not the clearance they're receiving from the mental health professional is sufficient. And just quickly, a quick anecdote, a case that I'm dealing with right now. I had a client match with the gestational carrier. The agency allowed the gestational carrier and the intended parents to begin communicating, even though screening had not taken place. Surrogate was a repeat carrier. She had been screened for her prior arrangement. She was sent back for a reassessment past that screening. But as I was beginning to draft the contract, I reviewed the screening that was done and noticed a couple of discrepancies, including a line in the report, which, by the way, was done telephonically, not in person. The gestational carrier's husband was not present at either assessment. And I noticed that there was a line checked off on the questionnaire that the gestational carrier had undergone marital counseling back in 2007, but there was no further explanation. So after discussion with my client, I recommended that an independent psychologist do a new assessment and that the gestational carrier and her husband both be present. And make a long story short, as a part of this new assessment, it was discovered that the gestational carrier's husband had been addicted to pain-killing medication that he had been receiving illegally for the last 10 years, that the gestational carrier had been sufficiently stressed out and anxious about it that she was considering divorce. And as a result of this new information, the independent psychologist disqualified this gestational carrier from being a surrogate. Unfortunately, the intended parents and the gestational carrier would like to continue to work with one another. We have withdrawn our legal clearance, and the doctor has not decided what to do now that they have conflicting psychological assessments. So really important that not only that we have psychological screening be done, but that there be some uniformity so that reproductive endocrinologists have some comfort level going forward, knowing that appropriate minimum protocols have been satisfied to avoid their own liability. Move on to the next issue, and that deals with contracting. When do we do the contracts? Now, contracts obviously set forth the expectations of the parties, so it's important, in my opinion, to complete this phase of the process prior to the gestational carrier or egg donor undergoing any invasive testing, and that includes mock cycles, soniohistograms, etc. And I will tell you, there is a real split in this community because many, in fact, the majority of IVF clinics do not require that contracts be in place prior to performing the medical screening. Only a small minority of IVF facilities do require contracts be in place. So that's an important issue, the timing of the contracts. And clearly having contracts in place protects the interests of the gestational carrier, the intended parents, and all parties involved, as it will set forth the remedies for each party in the event of a breach and possibly avoiding unnecessary legal controversy. I'm going to move over to pre-implantation genetic screening. I think there may be a couple of people in the audience that haven't muted their telephones. If they could, we're getting some feedback. So please make sure you've muted your phones if you could. Now, with respect to PGS, I'm acknowledging right up front that there's a controversy as to whether or not it's medically advisable and beneficial to use PGS testing depending upon certain medical circumstances. I also recognize that this portion is being presented anecdotally only, and the determination of whether or not to undergo PGS has to be made by the intended parents in conjunction with their doctor.
Now, can I pause your presentation for 1 second, please?
With pre-implantation genetic screening or pre-implantation genetic diagnosis, one of the big controversies right now is whether or not it's recommended, medically indicated for egg donors. Obviously, for age-related factors, dealing with patients who are in their 30s, doctors will oftentimes recommend it, but there is a divide whether or not it's appropriate for donor eggs. And as a legal practitioner, I'm certainly a proponent of doing PGS testing. And while the instances of genetically abnormal embryos may be lower when utilizing donor eggs, the use of PGS testing can reduce requests by the intended parents for medical procedures, including amniocentesis, CVS testing. It may avoid issues involving gender-based termination of pregnancies. Doctors will also recommend PGS to reduce the likelihood of miscarriage, decrease the risk of abnormal pregnancies, reduce the amount of time and additional costs that are involved with multiple IVF cycles, while increasing the likelihood of pregnancies with single embryo transfers. However, these procedures often have a financial, emotional, and legal component that potentially could harm the relationship between the gestational carrier and the intended parents. So really important, I think, that every reproductive endocrinologist have a conversation, as well as their attorney, with the intended parents about the advantages and disadvantages of preimplantation genetic screening. A couple other quick factors that ought to be considered. Many patients, after they have their first child, may be interested in family balancing, gender balancing, with respect to their second or third child. Using PGS allows for that and avoids what we have unfortunately seen too often, which is gender-based termination of pregnancies, which can give rise to conflicts between intended parents and gestational carriers. But it also gives the intended parents, particularly those working with donor eggs, an opportunity to create a sufficient number of embryos the first time. Oftentimes doing PGS testing will allow the doctor to determine that perhaps the egg donor is inappropriate, or there's an insufficient number of embryos for them to be able to complete their family, allowing them potentially to do back-to-back cycles to stockpile enough embryos so that they can complete their family and maintain the genetic connection between the children. Moving on to multiple embryo transfers. As many of you know from a lot of horrific news stories recently, multi-embryo transfers have resulted in numerous legal controversies concerning issues of termination of pregnancy, as well as fetal and selective reduction. There's perhaps the most notorious case right now that's ongoing. It's spawned at least 6 different lawsuits, including a federal court of appeal case that we're currently working on, is Cook versus Moore. And if there's a lot of lessons to be learned from that case, which I think was an absolute perfect storm, but among them is proper screening of a gestational carrier with respect to her views of termination of pregnancy, selective and fetal reduction, to make sure that both the gestational carrier and the intended parents share the same values when it comes to termination of a pregnancy. I mean, I can't say it any more simply than this, but we ought not be matching pro-life gestational carriers with pro-choice intended parents, or vice versa. The Cook versus Moore case is a perfect example of a pro-life gestational carrier match with a pro-choice intended father. And there was a lot of other screening issues involved that we really don't have time to go into, but among them was an allegation that the gestational carrier had lost custody of her own children. Allegations involving child abuse and spousal abuse, causing her to lose her own children, yet somehow she was approved to be a gestational carrier, and the reproductive endocrinologist proceeded with an embryo transfer of 3 PGS-tested blastocysts that led to a triplet pregnancy, and then a tremendous controversy when the intended father requested that the gestational carrier reduce, and asserting religious opposition to it, she refused to. Medical providers must also properly consult with their clients to ensure that the intended parents and gestational carriers are aware of the risk of multiple pregnancies, and that they're willing to assume those risks. And the last issue I would point out with respect to multiple embryo transfers is it's oftentimes easy in the confines of a physician's office or an attorney's conference room for intended parents to share what their feelings are with respect to termination of pregnancy or reduction in the event of a multiple pregnancy. But it's a much more difficult decision when you're in the treatment room staring at a 3D, 4D ultrasound on the day of a termination and reduction. And I can tell you I've had multiple situations where it has been my clients, the intended parents, who couldn't comply with their own wishes that we memorialized in the contract, because looking at a 3D ultrasound of their pregnancy and then having to make a decision about reducing or terminating it, not something they were really able to project and put themselves in that position. And making it impossible for them to even follow their own prior instructions. Moving on quickly, contracts and constitutional law. It's raised by these types of issues. And the question is, can parties contractually agree for a gestational carrier to behave in a certain way with respect to lifestyle, diet, exercise, travel restrictions? And the easy answer is yes. Nothing prevents the parties from doing so. They're encouraged to do so to ensure that we have a meeting of the minds and their intentions are memorialized. However, like with any contract, party can agree to act or forbear certain activities in exchange for consideration. Can the parties contract for selective reduction, fetal reduction, and termination of a pregnancy? Again, the answer is yes. Nothing prevents the parties from doing so. And again, they're encouraged to put that in the contract. But here's where it gets interesting. Can the intended parents request that the gestational carrier undergo a reduction or termination of the pregnancy? While the answer is yes, it can be requested, and it could potentially be a breach of the contract. The gestational carrier doesn't comply with the terms. The intended parents cannot require the gestational carrier to undergo such a procedure. Gestational carrier has the absolute right to make decisions regarding her own body, whether or not to undergo a termination or reduction. She has an absolute constitutional right to refuse to undergo a reduction or to be prevented from terminating a pregnancy against the intended parent's wishes. Now, many intended parents unfortunately believe that there are remedies available to them. And unfortunately, the remedy that most intended parents want is an equitable remedy, some type of court order compelling the surrogate to undergo a reduction or termination, or an injunction to prevent her from proceeding with it. Now, while breaching a provision in the contract requiring a reduction could open the gestational carrier and potentially even the IVF doctor to legal damages, there is no way to compel, to obtain equitable relief, to require the surrogate to undergo that termination or stop her from having one. So it's critically important that these issues be fleshed out and that the intended parents don't have an unreasonable reliance upon the contract, believing that they're entitled to some remedy. And then I'd like to close my discussion today with the role of the legal counsel. I think too many lawyers, having been trained perhaps with a litigation background, believe that any time there's been a breach, whether minor or material, sort of a reflexive reaction to try to litigate it, to declare a breach and try to seek whatever legal or equitable relief may be available. And unfortunately, I think that's counterintuitive. Gestational carrier agreements are delicate, and they dictate that we be very aware of the relationships between the intended parties and the gestational carrier. And it's the role of the attorney to foster a cooperative relationship between the parties, to act as counselors in encouraging the intended parents and the gestational carrier to reach an amicable and informal resolution to their disputes, rather than reflexively sending out breach letters, threatening to cut off compensation, terminating insurance benefits. Because at the end of the day, if there is an issue between the gestational carrier and the intended parents during the pregnancy, the destruction of that relationship will make the balance of the pregnancy difficult for all parties involved, leading to scenarios where even the intended parents may not be present for the birth of their child because the gestational carrier is punishing them, or leading to a custody dispute like we've seen in the Cook versus Moore case. So I think it's critically important that attorneys recognize that their obligation is not simply to look for some type of legal remedy, but that they also have an obligation to serve it as counselors to try to foster a resolution and recognize that there's always time after the birth of the child to address these issues. Again, I'd like to thank everyone for listening today and look forward to questions at the end. Again, thank you for your time.
Thank you very much. Dr. Hammond?
All right, thank you so much for having me. So I'm going to be speaking a little bit about the ethical and social considerations surrounding gestational surrogacy. And my background is that I've worked with egg donors and surrogates. I started working with them in India and then ended up working with them in the US. And my biggest focus has been in Canada. So just to start off, I have nothing to disclose in terms of conflicts of interest. So in this presentation, I'm going to first turn to the major ethical debates surrounding surrogacy transactions, so focusing in particular on those ethical debates surrounding clinics and agencies and their practices, and then I'm going to look at it a little bit in terms of the transnational context. So given the clinics and agencies' important role in most aspects of surrogacy transactions, I'm going to discuss some of the issues that arise in the literature and also that I've discovered in my own work. And I'm going to conclude by discussing the best outcomes for surrogates and for intended parents. So the main learning objectives excuse me, are first of all to gain an understanding of the central ethical debate surrounding gestational surrogacy, so on a broader level. The second are those in particular that pertain to clinics and agencies in the market of gestational surrogacy. And then the third is the important role of clinics and agencies in the ethicality of gestational surrogacy transactions. So in their own jurisdictions, but as well as when intended parents are going transnationally. So to look at the major ethical debates surrounding surrogacy, most of them can be lumped into about 7 categories, so there's 5 here. And at the basis of each of these are concerns around the role of money. So either as provided to the gestational surrogate or as the basis of the market of gestational surrogacy transactions. So the first argument is, of course, a moral one, and this is the most highly debated and has to do with gestational surrogates receiving payment. So the argument is that there are some things like blood, organs, tissues, and babies, and some services like gestational surrogacy that money can't, or rather should not, buy. So in considering this debate, however, we have to consider what exactly the money is for. So in egg donation, for instance, concerns with payment have to do with the morality of paying for eggs themselves, while in my own work with egg donors, I found that egg donors and intended parents describe payment as for the time, the effort, and the risks of donating. So it depends quite a lot on how it's framed. So similarly with gestational surrogacy, we have to consider what exactly the money is for in that situation. So is it for carrying and birthing the child as a service, or is it for the time, effort, and discomfort that's involved? So the second is the concern that payment for surrogacy crowds out non-market values, so that surrogacy might otherwise be done altruistically, and so that by paying for commoditizing surrogacy, we erode people's sense of obligation of altruism. So at the basis of this is the idea that monetary transactions then render life cold and distant and calculating. The third debate is around the stratified nature of surrogacy. And so in particular with gestational surrogacy, we kind of see this on 2 levels. So for intended parents, the cost of fertility treatment and surrogacy means that access to surrogacy is largely limited to global elites. And then on a second level, some studies have suggested that there's a particular demographic of surrogates. Of course, there's mixed evidence on this in countries such as the US, for instance, where some studies have indicated that surrogates are of lower socioeconomic status while others do not. But certainly research that we have from countries such as India, the Philippines, and Guatemala, for instance, have largely indicated that surrogates are largely of lower socioeconomic status. So the fourth aspect is the concern of undue inducement in gestational surrogacy transactions. So this is applicable to both the surrogate and intended parents. So for the surrogate, the concern is that she may be persuaded to enter into a surrogacy transaction because of payment, and that because of this she will not or might be unable to fully evaluate the risks, so those being physical, emotional, or social, of gestational surrogacy. And this arises as well for intended parents. So with a deep desire to have a child and the ability to do so through surrogacy can serve as inducement in not considering, for instance, the cost. So intended parents may be induced to pay more money than previously agreed to a surrogate. And we saw an example a few years ago in India where, for instance, a baby was held hostage by the surrogate. So fifthly are concerns over black markets in countries, for instance, where payment is not permitted. So for example, in Canada, surrogates cannot be paid beyond their expenses, but nonetheless, evidence has been indicating, and my research has certainly found that surrogates are being paid. So in the instances of these black markets, these surrogacy transactions are largely unregulated, and there is little recourse. So I'm going to come back to this in a minute when I talk about transnational surrogacy. But related to this are also concerns regarding trafficking and concern over unwanted babies being left, for instance, with their surrogate mother. So a sixth concern is over transnational surrogacy. So transnational surrogacy can be used in a number of contexts. So it may be used, for instance, to circumvent the laws prohibiting surrogacy or paid surrogacy. And it is used where there's a shortage of surrogates in the country where the intended parents are from. So for instance, many Canadians travel to the US because you can't pay for surrogacy in Canada, and so there tends to be a shortage. Women might also go to another country to provide surrogacy when surrogacy or payment for surrogacy is not permitted in their country. And so, of course, transnational surrogacy is largely unregulated. And in transnational surrogacy, for instance, these markets are often extremely stratified. And the prohibitive cost, again, means that this market is only accessible to some intended parents. And additionally, we have concerns regarding power relations between surrogates and intended parents. So the flow tends to be one where surrogates are often women of lower socioeconomic status, and this exacerbates concerns surrounding the undue inducement of surrogates. So a number of destinations that I've certainly found and that have been researched in the last couple of years are the US, India, and more recently actually is Guatemala. And some recent examples that we've seen are, for instance, where there's been instances of trafficking, or greater problems arising are, for instance, the baby Gami case, which resulted in attempts to shut down surrogacy industry in Thailand. And for those of you who've been following the news this past week, there's been a crackdown in the Philippines where it was discovered that Filipino women were being hired to travel to Cambodia to carry babies for foreigners. And so the seventh and final concern, and the one that I want to focus on the most, is concerns surrounding the role of businesses. So that is surrogacy agencies and fertility clinics in the ethicality of gestational surrogacy transactions. So there are a few components that I'm going to speak to about this. So firstly, the fertility market is a highly lucrative market. So as Deborah Spar, for instance, points out in her book, The Baby Business, fertility is a for-profit endeavor. And as a result, it raises the strong potential for conflicts of interest. So for instance, of fertility professionals prioritizing money-making over the care of intended parents and surrogates. And certainly across the existing research as well as my own, I've seen many examples of top-notch care for both surrogates and intending parents. Unfortunately, however, this is not always the case. And this market operates in a largely unregulated way, and so practices often receive little oversight. And so the effects of these conflicts of interest arise for both intending parents and also for gestational surrogates. So for intended parents, as we've seen, for instance, in some of the sociological literature, intended parents often have to and do become savvy consumers in the way that they have to navigate this industry. So through marketing and everyday practices, the compelling character of these technologies is shaped, compelling intended parents to use them and then to continue to use them. And so Karis Thompson, for instance, illustrates the role of fertility clinics in naturalizing the technologies. So individuals and couples are encouraged to try again. And in the case of gestational surrogacy, of course, there are emotional and financial risks involved for intended parents. And for gestational surrogates, on the other hand, they can often be considered secondary or subordinate to intended parents whose procreative intent they're working to realize. So the intended parents are the customer and thus can end up being privileged for this reason. And this potential for a conflict of interest arises in particular where both patients are receiving treatment from the same physician, which has occurred quite a bit in Canada. And so depending on the context, clinics and agencies may be involved in and can play an important role in all aspects of the gestational surrogacy transaction. And so Dr. Boonstenfar and Andrew Borzimar just discussed much of them, so I'm not going to go into too much detail, but of course, on the level of screening and matching, on informing surrogates and consent, in terms of care, in terms of physical and psychological care, and of course, in terms of the follow-up. And so because they are such a pervasive aspect of this transaction, the clinic or agency's role becomes a very critical aspect to the overall positive or negative experience of the transaction and also of the ethicality of it. And so there still has been limited work on gestational surrogates' experiences with clinics and agencies, but I would like to point to some of the specific concerns that are arising out of the existing literature that is specific to surrogacy, on infertility, and on third-party donation. So I'm going to just speak to a couple of things that have arisen in that literature. So firstly is the important role of care in intended parents and egg donors feeling that the surrogacy transaction was ethical. And I can't stress that one enough, because feeling as though they were cared throughout the entire process has an enormous effect on how people perceive the process as a whole and what their overall satisfaction was with it. So for intended parents, this often takes the form of them not feeling as though they're being shuffled along, particularly given the difficult and emotional nature for intended parents of receiving fertility treatment. And so for surrogates, the way that this manifests is in feeling as though they're an important part of the process, or the important one of the process. And so Anne Fisher and Mary Hoskins at the University of Victoria just released a study showing that there's often this discourse of the good surrogate that's encouraged by agency staff, doctors, and nurses. And basically this is the idea that there's a certain way that surrogates were expected to behave, such as, for instance, refraining from public displays of emotion, having no ambivalence in their ownership of the child, and of being secret about surrogacy. And at the basis of these rules is a privileging of the needs of intended parents. A third factor and fourth that I'm going to speak about together are the commercialism of surrogacy and the notion of well-run and poorly run businesses. So there's a discomfort surrounding commercialism of surrogacy by both surrogates and intended parents. And where the business nature of a clinic or agency is evident, but the business model is care-centered, gestational surrogates and intended parents report greater overall satisfaction with the transaction and end up feeling more at ease with the ethicality of the transaction. So the final point that I wanted to discuss in terms of this is the notion of intended parents staying versus leaving a jurisdiction for surrogacy. So this is particularly important given the concerns of transnational surrogacy or of how surrogacy transactions are conducted in other countries, and also given the finding that intended parents do not want or would prefer to be able to undergo surrogacy in their own jurisdiction. And so for these reasons, there's perhaps great importance in creating an environment in which intending parents do not feel as though they have to leave their own jurisdiction, or considering the added stress of transnational surrogacy, this gives us further reasons for why we need to provide increased support for those who are seeking surrogacy in our own jurisdictions. So in closing, I just want to leave you with an idea of what the best outcomes are for surrogates and intended parents, and considering both of these players in gestational surrogacy, and also thinking about best outcomes, not necessarily strictly in terms of medical and emotional and psychological, but even in terms of, for instance, for intending parents, the way that the process was organized by agencies and clinics ended up being an important component to how they felt overall about it. And so I want to stress the important role that clinics and agencies can play. They're profusely involved in the process. They can set the standards in terms of these ethical surrogacy transactions. And given that we do have a lack of regulation and lack of guidelines or often a patchwork situation, their role for leadership in this situation, I think, has the ability to play a huge role in standard setting and in dictating the overall ethicality of the transaction. So I will leave you there, but I want to say thank you so much for listening, and I look forward to hearing any of your questions.
Thank you so much. We'll now open up the floor for questions for our panelists. But before we start, I'd like to invite all attendees to join ASRM and Fertility and Sterility for the Journal Club Global discussion this evening at 7 p.m. Eastern Standard Time on mitochondrial DNA as a marker for ploidy and implantation in IVF. You can register for that event through the link you received by email or on fertsturt.org. Please send in your questions for this presentation through the chat box located in the gray toolbar to the right or bottom of your screen. The first question is for Mr. Borzimer. What about when the parties don't agree in principle on abortion, but agree that it won't be a breach for the gestational carrier to refuse?
Yep, there we go. Sorry about that. That's a really provocative question. I will tell you, since my practice is limited to only representing intended parents, if they have matched with the gestational carrier that has a different philosophy or belief system or value system when it comes to any type of termination or abortion, I would simply decline the representation. I would not move forward with a match if philosophically they were on opposite ends of the spectrum with respect to something like termination. As I mentioned in my presentation, I think all parties go into this with a certain expectation in mind, but things change. It's a fluid situation, and when you're sitting in a perinatologist's office at 20 or 22 weeks looking at a 3D, 4D ultrasound, oftentimes my clients are not able to follow through in the manner they thought they would prior to the pregnancy. So I am uncomfortable moving forward in any type of arrangement in which the intended parents and gestational carrier are not on the same page, philosophically, emotionally, religiously, and from a values standpoint when it comes to an issue like termination, because it's the one aspect of any gestational carrier agreement that I do believe is unenforceable, and I think the risk is simply too great.
Thank you very much. Unfortunately, we're just about out of time for the panel discussion. We need to wrap this up. So what I'd like to do is invite each of the attendees on the call to send their questions to me by email, and I will distribute them among the panelists. And we will record more panel discussion afterwards. Unfortunately, we can't continue the panel discussion now because there are other ASRM programs with which we are not able to overlap. So my email address is jgoldstein@asrm.org, or you can send your emails to asrm@asrm.org. Attention, Jessica. Thank you very much to our panelists and Professor Dar, and to our presenters and attendees. This session was recorded and will be available on our website in the near future. Please keep an eye out for the announcement of our next webinar topic for March. For any further questions or comments, please don't hesitate to contact me at asrm@asrm.org. Attention, Jessica. And this concludes the webinar.